daughter, Gabby. Tonight, we have the latest from the courtroom and a live interview with the Laundrie's attorney.
I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. And when you think of Gabby Petito, you think of a very typical young woman. We see so many in our society that want to experience life, you know, not just like do the old 9 to 5. No, go out, see things, make an adventure, make it very public, and maybe even turn it into a business. I mean, this public life that Gabby Petito was living was what she wanted to do. And she wanted to share that with her boyfriend, Brian Laundrie. I mean, that's why they began this adventure living out of her van. Gabby had the support of her family, really an amazing family that she had. Her parents had gotten separated and both remarried, but everyone working together, getting along so well, and supporting Gabby. She really had a great infrastructure for life, to live that amazing life that she wanted to live. But as we all know, she disappeared. And when she disappeared, there was a huge hole in the family, in the lives of everyone who loved her. Where was she? What happened to her? We're so desperate to fill that void. That void never got filled. It never got filled. Now, at the time that she was missing, what we do know is that Brian Laundrie and his parents knew that Gabby was missing. They knew. How did they know? Well, you know, they all took off from Florida in the van. They took off, and when they came back, just Brian was in the van. There was no Gabby. So Brian knew exactly what happened. What his parents knew was that, okay, Brian is home with her van, but without her, and it's time to call an attorney. So, you know, they knew something was wrong, and they knew that Gabby was missing. But that information was never given to Gabby's parents. Never. No calls returned, no messages returned. And it was frustrating for them. It was maddening. I mean, we all, I think, could put ourselves in those shoes and say, wow, my daughter's missing. We know who knows something, but they won't say anything. Help us. That's what they wanted. They pleaded for it. Well, we know how this all resolved, right? How this ended up. Gabby's dead. Brian Laundrie's dead. So we're left with two sets of parents. And the parents of Gabby Petito, they want to make Brian Laundrie's parents talk. They've sued them in civil court. Intentional infliction of emotional distress. When you sue someone, it's a civil case, much different than criminal cases. I sue someone, I can depose them. I sue someone, I can put them on the stand, have them take the oath and answer questions. And at a minimum, I believe that's what they want. At this point, they've clearly been damaged beyond damage, but there's still answers they don't have. Chanley Painter, Court TV legal correspondent, is joining us tonight from outside the Sarasota County Courthouse in South Venice, Florida, where today this civil case was on the docket in front of a judge. Chanley was at the hearing. Who else was there and who was not there today, Chanley?
Hey, good evening, Vinny. This was a pivotal hearing for the parents of Gabby Petito, who arrived in court solemn, sad. You could just see and sense on their body language as they walked into the courthouse, into the courtroom, what this means to them. Still tearful as they sat and listened to the arguments unfold before them. And I got caught up with their attorney. They were relieved that the Laundrie parents, Chris and Roberta, were not. in court, didn't have to make FaceTime with the Laundries. In fact, I went to the Laundrie home today, earlier, Vinnie, to see if they were there. And indeed, I did see Christopher Laundrie in his driveway. He was actually vacuuming out his truck. There's this familiar sight. We watched this home for weeks when Gabby was missing, when Brian Laundrie was missing, and same vehicles in the driveway. And there we have Christopher Laundrie vacuuming. Right before the hearing earlier today, I tried to approach him, ask for a comment. He had no comment. Of course, he abruptly stopped vacuuming and went back inside his home. And the neighbors I also talked to, very busy neighborhood, Vinnie, were defensive, almost protective of the Laundrie family, given what we witnessed and covered months ago, which was a media circus outside the home, protesters outside the home. So very much a neighborhood still on edge and alert to any issue dealing with this case. So the Laundries weren't there today. They also weren't streaming or listening in. Their attorney was one of them streaming, listening in, one, of course, arguing on their behalf. And I did catch up with their attorney in court today asking, why weren't they here? He said it's typical, Vinnie, that his clients wouldn't show up for just a pretrial motion hearing.
So tell us about today's hearing. What happened? What was on the docket? And was there any resolution, any decision by the judge?
Sure. So first, of course, Matt Luca for the Laundries arguing to dismiss this lawsuit altogether, saying that the Laundries had no legal duty to speak up, to reveal what they knew, if anything, during the time of Gabby's disappearance. And, of course, that they were within their constitutional rights in order to remain silent and to speak through a lawyer, which is what they did. A key issue today was whether or not their conduct was so outrageous, quote unquote, quote, outrageous, the legal standard, to cause intentional infliction of emotional distress, the basis of this lawsuit against them. And the attorney for Petito's parents, Pat Riley, he cited a bunch of case law trying to convince the judge that the conduct or the course of conduct over the days and weeks by the Laundries did establish this outrageous conduct, their lack of communication. Let's take a listen.
They could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously. They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was.
Vinnie, Judge Hunter Carroll did not make a ruling from the bench today. He did advise the parties that he would issue a written decision within 2 weeks from today.
That will determine whether or not this case can go forward or not. Now, you also spoke to the Petito family's attorney about some of the evidence today.
I did. I caught up with him after the hearing earlier today to inquire further about how he felt about the proceeding. He felt confident, and especially confident in some of the questions the judge was asking of the Laundrie attorney during the hearing. He feels that this will survive this motion and continue forward. But I was keen because, like we just heard him describe, these very incriminating allegations of the behaviors of the Laundrie parents, covering up for their son, helping conceal where he was, etc. And I asked, what evidence do you have to support this? Let's listen.
We haven't received from the FBI yet all of the information that they have, but the information that we understand is available is that Brian Laundrie did confess to the murder in writing and on some app. Orally, he confessed to it, and so that's part of what we have to. And the phone calls, as I said, are circumstantial evidence. The murder occurred, we think, on the 27th. He called his parents. They immediately called the lawyer. Why would they need to call a lawyer?
And what else does that notebook
We lost Chanley Painter down there in Sarasota County, but let's bring in a very special guest. Joining me now in East Islip, New York, is the attorney representing the Laundrie family, Stephen Bertolino, is with us. Stephen, thank you so much for joining us tonight. We really do appreciate it. I know a lot of people want to talk to you, and we appreciate your time tonight.
Yes, good evening, Vinny. Thanks for having me.
Can I start here? And I want to clarify this for myself and obviously for everyone watching. I always introduced or spoke about you as the Laundrie family attorney. Did you represent Brian? Do you represent Chris and Roberta, the parents? Did you represent all of them, just some of them? Can you clarify that for us?
Yes, well, I've spoken on this topic a couple of times, and throughout the course of the ordeal back in September and October, I did represent all three parties and in different capacities. As of now, I am representing Chris and Roberta.
Okay, so at the time you represented all three, did you have contact with all three? Brian
I did.
And Roberta and Chris?
I had spoken to Roberta and Chris. I had spoken to Brian. I spoke to them separately, and I spoke to them together.
Okay. I want to get to today's hearing because one of the big issues that was brought up today was a statement which you released September 14th of 2021. I'm going to put it up on the screen so our viewers can see it and everyone can understand what we're talking about here. And it says, this is a statement from counsel for the Laundrie family. This is understandably an extremely difficult time for both the Petito family and the Laundrie family. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. On the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. And here is one of the issues that was brought up in court today from the Petito family side, is that from this note, especially the lines, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family, that he gave them false hope, misled them that Gabby perhaps was alive and would be found and would be reunited with the family. Was this misleading, this note?
I don't believe the note was misleading at all. I think the note was a generic, I should say the statement. The statement was a generic statement put out. If you recall, the presence of the press was bountiful, to say the least, and everybody was clamoring for some statement or some comment coming from the Laundrie side. We only know certain things at the time that they're told to us. Just as you heard Mr. Riley say today that he doesn't have all the information from the FBI. I did not have all the available information on the date that statement was released. Chris and Roberta, had probably less information than I had. And when all said and done, if you take that statement standing alone, it is not an outrageous statement. It's not an intentionally harmful statement in any way. And I think it's a generic statement that just about any defense lawyer would put out when pressed for a comment as to the investigation that was going on at the time.
I guess the real issue associated with this is the timing, September 14th. Brian had returned in the beginning of September, wasn't it? Like September 1st or so when he got back to Florida, about that time. And I guess the indication is that at that point, I mean, he knows that Gabby's not alive. So is what you're saying here tonight that you wrote this statement and based on the information you had, that you didn't have the information about where Gabby was or what happened at that point?
Well, what I'm saying is, at the time that statement was put out, it was very early in the episode or the saga, if you will. The information that I had was certainly privileged. The information that I could share with the public and the press was put forth in that statement as to what we knew, that there was an investigation going on. And let's cut to what happened today. I mean, this statement obviously became the crux of the proceeding. And in the end, if you think about what Mr. Riley was discussing, he struggled, in his words, to find some basis upon which to file this lawsuit. And he struggled to find some duty that the Laundries may or may not have had to divulge or speak or say anything. And he couldn't find any such duty. He couldn't put forth to the court any such duty. So the only thing that the Petito family has, and the only thing that Mr. Riley has in connection with this lawsuit to stand on would be this statement that I put out, which, standing alone and reading it, on the words that are written on paper, is not atrocious. It's not utterly intolerable. It's certainly not outrageous. It's certainly not mean-spirited in any way. And again, I represented clients for many, many years. Sometimes they tell me the truth. Sometimes they don't tell me the truth. And in the end, my firsthand knowledge is my firsthand knowledge. What I can put out there is based upon my firsthand knowledge. And that was that there was an investigation being conducted. And it was my hope that the Petitos would be would be reunited with their daughter.
Now, and I guess that the problem they have is that it seems, is it you speaking or is it the Laundrie family speaking, right? There's always a little bit of gray area when it comes to lawyers. They used to call us, I'm a lawyer too, mouthpieces, right? That we speak, like our clients speak through us. And the Johnny Depp trial was actually mentioned today. The one count that Johnny Depp lost was a statement made by his attorney on his behalf that the jury and the judge and everyone agreed could be attributed to Johnny Depp. So from this perspective, are you saying this statement should only be attributed to you and not to your clients?
Well, Vinny, I heard that part of the judge's comments as well. And, the law is the law. So, we're bound by that. And the law in Florida is such that, as you point out with the Johnny Depp case, the client is bound by what their agent, in this case the attorney, says on their behalf. And my statement clearly says, on behalf of the Laundrie family, this is what we're putting forth. So with that in mind, knowing that we're bound by the statement, we can't change the statement. I can't sit here tonight and tell you that it's not the Laundrie statement, that it was mine. What I can tell, under the law that is, what I can tell you is that I prepared the statement. Chris and Roberta did not. I put the statement out there. It is my statement, but I'm not going to say that the judge is wrong under the law, that it should be applied to the Laundrie family. But let's move to the point at hand. If you're going to say that this statement, or more precisely, if Mr. Riley and the Petitos are going to say that this statement is the basis of an intentional infliction of emotional distress claim, then let's look at the elements of that claim and come right to the outrageousness of it. You've had that statement on the screen several times. I've read it many, many times. That's not an outrageous statement. It's not utterly intolerable in a civilized community. And in fact, I think it's the type of statement that just about any defense attorney would put out when they are pressed for a comment from the press. Certainly we could say no comment all the time, but a softer approach rather than no comment is to say, hey, look, we understand what's going on. We understand you're going through a difficult time. We're going through a difficult time here. At the moment that statement was released, Brian had left the home in a distraught manner, as I had put out once before, and his parents were concerned about him. So in the context of the face of the statement, it's not outrageous. So if that's the only thing that that Mr. Riley and the Petitos are using to form the basis of this lawsuit, I think it fails. Of course, we respect the judge. He asked a lot of good, deliberate questions of both sides today, which was, comforting, sitting in my chair. He certainly asked Matt Luca several questions, certainly asked Mr. Riley several questions pertaining to that. and I think he was fair in his questioning, to the extent that I think the judge, really is in tune with, the point of whether or not this statement would be outrageous. And I think he was quite clear that he believes under Florida law, the statement should be attributed to Chris and Roberta Laundrie. And if that's so, let's move to the next step. Even if that statement is attributed to Chris and Roberta and or myself, is it outrageous standing alone?
Great analysis. I get it. I think where the discrepancy here is if you know she's dead and you're saying it is our hope that it's a successful search and she's reunited, it's giving them false hope to a family that is distraught. And I think that's the argument for the outrageousness. I understand you completely disagree with that, but I just wanted the folks at home to understand both sides of this. Stephen Bertolino, the family attorney for the Laundries, Brian Laundrie's parents, staying with us. Have a whole bunch more questions for you, Stephen. I appreciate your time tonight. Also, coming up in the next hour.
Big breaking news in Cobb County, Georgia tonight. Ross Harris was convicted of intentionally leaving his 22-month-old son Cooper in a hot car to die back in 2014 so he could live a child-free life. Now, the Georgia Supreme Court has overturned his conviction, and tonight we have the latest in this shocking decision.
They tried to make it look like he was sexting on his phone knowing his child was in the car.
And that's not true.
He was sexting on the phone, there's no doubt about that. But they never did prove that he knew the child was in the car.
you choose.
All right, what I need from everybody here is help, because the goal is still not met, and that goal is to bring Gabby home safe, all right? And I'm asking for help from everyone here. I'm asking for help everyone at home. I'm asking for help from the parents of Brian, and I'm asking for help of the family members and friends of the Laundrie family as well.
That was Joe Petito asking for help early on in the search for his daughter, Gabby, at a press conference. Now, Gabby's stepfather, Joe Schmidt, a little bit later on, was out in Wyoming during the search. I had an opportunity to speak to him when he was out there. Take a listen.
We have had no communication between our family and theirs. It's absolutely absurd. We don't understand why. They were traveling together. At some point, you left there. We know you've been home since September 1st. You know something. And the fact that you're hiding behind your attorney, which we understand your constitutional rights not to speak, but it doesn't make any sense to us. None whatsoever.
And the attorney for the Laundrie family, now the attorney for Brian's parents, Stephen Bertolino, still with us. Again, appreciate your time tonight, Stephen. It was painful for all those parents. I mean, for the stepdad, dad, mom, stepmom, they all heartbroken in this search. And that silence that they were getting, the lack of any sort of information to them was very puzzling. Stephen, why not let them know something?
Well, if you go back in time, I've said it numerous times, Chris and Roberta remained silent at my direction. I think I said that as early as September 13th, which was Monday. And I continued to say that throughout the process. Sticking to the issue at hand today in the court proceeding, this was only about a motion to dismiss. And during that, the motion and what the court has to evaluate is taking all of the allegations within the complaint as true. So you can say, why were we silent? For today's purposes, it didn't really matter. Everything that the Petitos are alleging is deemed as true, even though we've denied them. And what it comes down to, the question of whether or not we can remain silent, I just heard Mr. Schmidt say, we understand their constitutional right to remain silent, but we don't understand why they're not communicating. If he truly understood the constitutional right to remain silent, as was brought up in the court proceeding today, that right doesn't start when a criminal investigation commences. That right starts all the time. I mean, no other way to put that. It never ends, I should say. It's a continuum. And you don't wait for the police to say, oh, by the way, I just opened a file and it's got your name on it. When there's an occurrence of an event, the police may investigate or family members may investigate, and they come looking for information. The right to remain silent exists at that time. And that was one of the issues that was brought up today. And there was some back and forth in the courtroom. But I think the law is clear that there doesn't have to be a criminal investigation for parties, whether it was Brian, whether it was Christopher or Roberta Laundrie. They had the right not to speak. And I advised them of those rights. And I told them to exercise those rights throughout the September and October months. And continuing to this day, I've told them to do that. So why not speak? If you're a lawyer, Vinnie, and you've practiced any criminal law at all, I don't think you've ever advised your client to speak unless they're ready to take a plea bargain.
Yeah, and well, I was a prosecutor, so I want them to speak all the time, Stephen. You know that.
Yeah, so if you're looking
here's
for
my
an
question.
allocution,
Here's my question,
if
though.
you're looking for an allocution, you want them to talk.
Right.
But if you're on the other side of the rail, you know as well as I do. You keep your mouth shut, you don't say a word.
How about this? this case, say it survives the motion, this civil case continues. It's time for depositions. Is Chris, is Roberta going to speak when they're asked questions during a deposition?
Well, as you know, the right against self-incrimination is going to follow him throughout the civil trial, and the judge pointed that out as well. You know, if the procedure has to be that they invoke the right against self-incrimination to each and every question, they very well may do that. But we're not focusing on that. I mean, we're certainly prepared. If this motion does not go our way, we will take the next legal steps that we need to do to protect the Chris and Roberta Laundrie. But in the end, the Petitos have the right as well to take all necessary procedural steps to see that what they want done is done within the courts. And we're just doing the same thing on the opposite side.
Let me ask you this, because this is what everyone's thinking at home right now. Brian Laundrie's dead. Everyone believes he's the one absolutely that murdered Gabby Petito. Chris and Roberta didn't do anything. If you're taking the fifth, and this is a conversation we have a lot here on Court TV, someone taking the fifth, and then what are we supposed to take away from that? What is the public supposed to take away from that? I know it can't be used against you, but what do you think the public should take away from the fact that they're exercising their fifth? We know they didn't kill Gabby.
So when you use the pronoun, you know, we know they, you're saying Chris and Roberta, correct?
Correct. We know that
Okay.
Chris and Roberta had nothing to do with the death of Gabby Petito. So what's the concern that they may incriminate themselves about what?
So again, dealing with what was on the table today in court, we're dealing with within the four corners of the complaint on each page and the allegations that were set forth. And there was some back and forth between the judge and Judge Carroll and Mr. Riley with respect to whether or not there was some allegation of criminal activity. And, you know, Mr. Riley, you know, tried to say that there wasn't. But meanwhile, he says that Chris and Roberta had assisted Brian in trying to escape. And, you know, that clearly doesn't make sense. If you go back in time, as you just said a few moments ago, everyone believes that Brian came home on the 1st. And if that's truly the date and the police came knocking on the door on the 11th, that's 10 days. So if Brian was home for 10 days and they went camping and they did all these other things, where is the criminality in that? There is none. However, the criminal investigation that the FBI conducted during you know, the course of September certainly included Chris and Roberta, and I know that for a fact. That's not something that's within the four corners of the complaint. But I had multiple conversations with the FBI with respect to potential charges against Chris and Roberta. They didn't go very far. And in the end, there was a lot of speculation that Chris and Roberta were helping Brian. In fact, many of the news outlets were putting on pundits who were, you know, speculating as to burner phones and, you know, Appalachian trails and things of that nature. So when you have clients that are under that kind of scrutiny and that kind of pressure, you want them to come forward and speak, or you want them to sit silent and not take the risk that something they say is going to be turned and used against them. And as a prosecutor, you know, the defense attorneys are always going to advise their clients not to say a word. And that's what I told them to do. And that's why they invoked their Fifth Amendment right against self-incrimination.
All right, Steve Bertolino, Laundrie family attorney, staying with us. You're in lockdown tonight with us, Steve, and we're not letting you go. Have a few more questions for. Yeah, we have a few more questions for. We're going to go through a little bit of the timeline of this case. We'll be right back.
As you're aware, the FBI and the Northport Police Department and our state and local law enforcement partners have been searching the area of the Carlton Reserve for Brian Laundrie, a person of interest in the murder of Gabby Petito. Earlier today, investigators found what appears to be human remains, along with personal items, such as a backpack and notebook belonging to Brian Laundrie. These items were found in an area that up until recently have been underwater. Our evidence response team is on scene using all available forensic resources to process the area. It's likely the team will be on scene for several days. I know you have a lot of questions, but we don't have all the answers yet.
with worthy.com.
It was here at the vast Carlton Reserve, not far from this entrance, where authorities located the remains of 23-year-old Brian Laundrie. This after weeks of search crews wading through flooded trails and swamps. Located near those remains, the authorities also uncovered a notebook, a revolver, a backpack belonging to Brian Laundrie. This notebook also contained a suicide note where Laundrie confessed to killing Gabby Petito.
Okay, We have a few more questions that I need to ask Stephen Bertolino. He is the attorney, the family attorney for the Laundrie family. Stephen, do you see any scenario where your clients, the Laundries, could sit down with Gabby's parents and answer questions with or without lawyers, perhaps as a way, you know, a strange way maybe to settle this lawsuit and just, you know, parent to parent, have that conversation and share some information? Do you see that potentially happening under any scenario?
You know, it's funny, Vinny, that you asked me that question because, you know, when Brian's remains were first discovered and found, I kind of posited something like that. When somebody asked me a question, I said, yeah, I don't know where this goes. There may be a point in time when there could be conversations, and that was the word I used, between the families. I'm never going to say never because I don't know where it'll go. I can tell you that, you know, Chris and Roberta have lost a child. They've lost their son. Many people ask me how they're doing. People have just recently starting to recognize that, you know, Chris and Roberta really had no, you know, nothing to do with Gabrielle Petito's murder, and yet they are, you know, suffering just as badly as the Petito family. That being said, there's certainly no olive branch being reached across the aisle when the only communication was filing of several lawsuits against the Laundries. Had one of the attorneys for the Petito family reached out to me as collegial as they should, instead of doing it by Twitter or an open letter to the public, you know, perhaps we could have resolved some certain issues many, many months ago. But that's not the path that the Petito family has chosen. So we'll walk down the path with them that they've chosen to walk down. And if they choose something different, then one of their attorneys will have to reach out to me.
Do you know what's in that notebook? Have you read it? Have his parents read that notebook?
I can tell you that the parents had been shown some excerpts in the notebook, but they were very upset and distraught at the time. And I've spoken to Chris and Roberta, and there's a vague recollection of some of the writings that were in there. I personally have not seen the notebook. I've been advised from certain parties as to the contents of certain things that are in there. And, you know, we'll have to wait and see what gets disclosed from that notebook in due time.
I wanted to go to one of the dates on the timeline from the lawsuit that was filed by Gabby's parents. And in particular, August 28th of 2021, it is believed Brian Laundrie advised his parents that he had murdered Gabby Petito on the same day Christopher and Roberta spoke with attorney Bertolino. Are you guys disputing that?
Again, with the motion that we filed, we are kind of bound that everything the Petitos allege is deemed as true. So in the context of the motion to dismiss, we have to go under the guise that everything is true, although we dispute it. With respect to that specific statement, yes, we're disputing that. The allegations in the complaint, you know, include that. We've addressed it accordingly, and if and when this lawsuit proceeds, we'll have to address, I presume, those questions, or Chris and Roberta may be faced with those questions if it goes to the deposition stage.
All right, Stephen, I want you to stay with us. One more segment. Long night for Stephen Bertolino, but he's been very kind to us. And again, we do appreciate it because I have some other questions about the public reaction and everything else that your clients have dealt with and will continue to deal with in the days to come. Also, folks, coming up in the next hour.
On the docket tonight in Los Angeles, California, the murder of hip-hop legend Nipsey Hussle.
On March 31st, 2019, Eric Ronald Holder Jr. shot and killed Nipsey Hussle. But he was shot from literally from the bottom of his feet to the top of his head.
Find yours at Nix.com.
This is the home of Chris and Roberta Laundrie, where Gabby Petito and her fiance Brian Laundrie lived before their cross-country van life trip. Now, if you remember, in September of 2021, for weeks, media staked out this property, protesters staked out this property, demanding that the Laundries speak out. What happened to Gabby Petito? What happened when their son Brian Laundrie went missing? But they never would speak publicly, only through their attorney.
Let's take a look at some of what Chanley was describing there. It wasn't that long ago. You've got folks protesting outside of the Laundrie household.
Where is Gabby? Where is Gabby? Where is Gabby? And I do you know? You better start talking, boy.
And the attorney for the Laundrie, Stephen Bertolino, still with us here tonight. Stephen, your thoughts about, and you know, there's a couple things going on, right? There's the lawsuit now that your clients are dealing with, the civil lawsuit, but then there's also like real life and the rest of their lives. So what are your thoughts tonight about the way Chris and Roberta have been treated by folks like me and the media and the public in general, and how has it impacted their lives?
You know, I'm starting to laugh because I think they were treated horribly by the media. I think the media needs to check itself. I can tell you that I had several words with some producers for the media when they wanted me on their shows, and I challenged those producers to put me on some very popular shows at their request, only under certain conditions, so that I could confront the pundits and the so-called legal experts who were broadcasting rubbish and garbage about, you know, putting Brian on planes and buses and burner phones and things of that nature, all speculation. And I understand that, you know, the media needs to fill the time in their 24-hour news cycle, but they went from reporting the news to making up the news, and it was just horrible. With respect to the public, certainly the public has a right to intervene and protest, but I don't think it's acceptable in our society, our civilized society, to have people protesting outside of anyone's home. There are, you know, calmer and better ways to do it, and the fact that they have the right to do that on a public street is a great part of America and a great part of American life. But it comes to a point where we were really fearful for Chris and Roberta's safety in the house, and at some point Chris and Roberta thought about leaving, and there really was no place for them to go that would have been, you know, as safe as their own home. So you can say, well, too bad, you deserved it. I've had people say that, you know, to me, and, you know, I don't agree with that. I think we don't do witch hunts anymore. We don't do public hangings, and that's what this mob did, and the media supported it. And if you go back and you review the tape, you'll see that I'm correct. The media pushed this, this public raucous, this circus, as it was described, I think even earlier by Chanley. So that's my reaction to it. I have no warm and fuzzy feelings for the way the press handled this particular saga.
We have about 30 seconds or so, Stephen. Do you think, though, that if Chris and Roberta did speak publicly and pour their hearts out about their perspective of what happened here, that it could help?
In the past or in the present?
Going forward.
Going forward, we can't speak. They can't speak, especially with this civil lawsuit going on. You know, will it help what? Will it help heal some wounds? Will it help give some closure? I can certainly tell you there are a lot of things that are unknown that, you know, for the time being have to remain unknown. Whether or not they're disclosed in the future, that remains to be seen. How they're disclosed in the future remains to be seen. Right now, we're focusing on this civil lawsuit.
Absolutely. Stephen, we're out of time, and I just hope everyone noticed how carefully you chose your words because of your ethical obligations Stephen Bertolino, appreciate all your time tonight. I hope you'll speak to us again.
Vinny, thank you for having me. Have a good evening.
We'll be right back.
Four.
Big breaking news in Cobb County, Georgia tonight. Ross Harris was convicted of intentionally leaving his 22-month-old son Cooper in a hot car to die back in 2014 so he could live a child-free life. Now, the Georgia Supreme Court has overturned his conviction, and tonight we have the latest in this shocking decision.
They tried to make it look like he was sexting on his phone knowing his child was in the car.
And that's not true.
He was sexting on the phone, there's no doubt about that. But they never did prove that he knew the child was in the car.
And we take a closer look at the evidence in the case. Did he really intentionally kill his son? And what impact did all the evidence about all this sexting and affairs have on the jury?
They fairly deliberated and discharged their duties and found the defendant guilty of what factually was a horrific experience for this 22-month-old child.
On the docket tonight in Los Angeles, California, the murder of hip-hop legend Nipsey Hussle.
On March 31st, 2019, Eric Ronald Holder Jr. shot and killed Nipsey Hussle. But he was shot literally from the bottom of his feet to the top of his head.
Plus, Ross Harris claimed it was a tragic accident. He did not intentionally leave Cooper in the car. Tonight's 13th jury question: do you think it's really possible to forget your child was left in your car all day long? Get ready. This hour of closing arguments starts right now.
I'm Vinnie Politan. Thanks so much for joining us tonight. We have really big news in a big case from 2014. It was about the death of a little boy, 22 months old, died a horrific death. There he is. Cooper Harris was his name. Left in the back of a car, locked in the Georgia heat all day long. Horrific. His father, Ross Harris, you're seeing his pictures here with his son. Got another picture of Ross Harris. This one not with his son. That's his mugshot. He was arrested. He was ultimately charged with the murder of his son, not for accidentally leaving him in the car, but for doing it intentionally. He was convicted. He's getting ready to serve life in prison. But today, the big news, that conviction overturned. We're going to talk a lot about that story tonight. For those of you not familiar with what happened to Cooper, here's Court TV legal correspondent Chanley Painter.
On the hot, humid morning of June 18, 2014, Justin Ross Harris strapped his 22-month-old son, Cooper, into the rear-facing car seat in his SUV before heading to work.
And I know how much he loved Cooper. I mean, he loved Cooper with his whole heart. I mean, there wasn't nothing he wouldn't do for that child. He cherished him. Yeah, he did.
Surveillance video captured Harris holding Cooper and ordering breakfast at a Chick-fil-A near their home. After leaving the restaurant, Harris said he intended to drop off Cooper at a daycare in the Home Depot headquarters in Metro Atlanta, where he worked as a web designer. But after he left work, Harris says he made a devastating discovery. Little Cooper was still in his car seat. The toddler had been trapped in the hot car for more than 6 hours, with temperatures in the vehicle reaching above 100 degrees. An autopsy later confirmed Cooper died of hyperthermia. Harris was arrested later that night. And after a 3-month investigation, Harris was indicted by a grand jury and charged with 8 counts, including malice murder, felony murder, and cruelty to children in the first degree. Prosecutors added more charges after they found that Harris had been sending sexually explicit text messages to at least 6 women, including a teenager.
They tried to make it look like he was sexting on his phone, knowing his child was in the car.
And that's not true.
He was sexting on the phone, there's no doubt about that. But they never did prove that he knew the child was in the car.
Investigators say in the days before Cooper's death, Harris made online searches related to babies in hot cars, statements that would later prove untrue. Nevertheless, the damage was done in the court of public opinion. Harris's attorneys asked for a change of venue because of extensive pretrial publicity. Harris's mother, Evelyn, told Court TV the media attention was unbearable.
And everything was so publicized before the trial that there was no way he could have gotten a fair trial. No way, because the press had him pronounced guilty before his trial.
The judge agreed and moved the trial 300 miles southeast of metro Atlanta to the coastal city of Brunswick in Glenn County, Georgia. During the trial, prosecutors portrayed Harris as a man who had been living a double life. They said he intended to kill his son Cooper because he wanted to live a child-free life. The jury heard testimony from several women who Harris had been sexting on that fateful day. But the defense said Harris was a loving father who experienced a memory lapse, who simply forgot to drop his son at daycare. Harris's then wife, Leanna, said he was forgetful and absent-minded when she testified for the defense.
Was he the kind of person that was very focused, or was he easily distracted?
I would say he's easily distracted. I guess a good example would be, maybe getting a paycheck and forgetting to cash it.
After about 5 weeks of testimony, the jury convicted Harris of murdering his son Cooper. The judge praised the jury for its verdict when she sentenced Harris to life in prison without the possibility of parole.
They fairly deliberated and discharged their duties and found the defendant guilty of what factually was a horrific experience for this 22-month-old child.
So little Cooper loses his life. At trial, Ross Harris is exposed as some sort of sexual addict who is texting and sexting and cheating on his wife and all. So I looked at this case and I'm like, what about Cooper's mom? All of this at once she has to deal with. Leanna's her name, and joining me now in Atlanta, Georgia, the attorney who represents Cooper's mom, Leanna Taylor. Lawrence Zimmerman is with us. Lawrence, great to see you. Thanks so much for joining us tonight. You're the first person that I contacted after getting this information today about this decision. First of all, Leanna, has she released any statement? Does she want anyone to know what she is thinking on this day that Cooper's dad, Ross, his conviction was overturned?
I spoke to her this morning as soon as I learned the good news. Trying to think, how do I frame it? She's obviously moved on. This is the most tragic thing that could ever happen to a person, losing your child, losing it in such a public and horrendous way, and being shamed by the media and by everybody else that she believed that her husband was innocent of intentionally killing their child. So she's grateful to the Georgia Supreme Court for seeing through Cobb County's shenanigans. She's grateful that, I say vindicated, but Cobb County's overreaching what they did, what they dragged her into, the extrajudicial statements that were made, the things that happened piece by piece that was leveled against her. She was tried in the media. It was like the Salem witch trials. She compartmentalizes that part of her life. She doesn't have to try to think about it every single waking moment. So she's relieved. So, she hasn't released a statement publicly yet, but I'm speaking, someone on her behalf, and I'm just giving a little insight there.
How about your reaction today to this decision?
I wasn't surprised at all. I think I actually texted you when I first found out after watching, well, first of all, let me back up. After watching the trial and seeing what the prosecution was allowed to present as evidence, I think if we go replay some of the conversations years back on the former show we used to do, you would see me being outraged by the things that they were allowed to present and the judge let them present. Now, fast forward to this year, when I watched the Georgia Supreme Court and the oral arguments that the lawyers made in this case on the appeal, I knew right then, I was 99% confident this case was coming back and going to be reversed based on the pointed questions by the justices that they were asking the Cobb district attorneys. So I wasn't surprised, but I've been checking every Monday morning, because that's when opinions usually come out. It was a holiday this Monday. I've been checking every Monday morning for opinions to see when this would drop, and it finally did.
So, you're not only representing Leanna, you're a great criminal defense attorney in Georgia, former president of the defense attorneys. So what happens now? So a lot of people are wondering, would he walk out of prison now? What are the steps that have to take place after something is overturned? Because he could be retried, right?
Right. So the appellate lawyer, which was not Maddox Kilgore, Carlos Rodriguez, who were the trial lawyers, is obviously someone different, and we can talk about why later. But the appellate lawyer, Mitch Durham, who did a fantastic job, did not challenge a couple of the other convictions, which were related to sexting an underage person, which he got a 12-year sentence on that. So he's still going to do prison time on that, but all the murder charges were thrown out. So it'll go back to Cobb County, and there's a new DA in town, Flynn Brody. I guess he could decide whether he wants to retry the case or, in my opinion, do the right thing and resolve it favorably for what this case may be, some kind of criminal negligence. And now there's actually a Georgia new statute came out after this happened, second-degree murder for criminal negligence, like leaving your child in a car. I'd be shocked if Cobb County doesn't go back and relitigate this case. All the people are gone. Chuck Boring is now the head of ethics for the Judicial Qualifications Commission. Jesse Evans is in the different counties and going to be the police chief of Ackworth. Everybody, took this case and moved on to different positions. Vic Reynolds, who's the DA in Cobb County, is now going to be Superior Court judge. I'm assuming the governor's going to appoint him sometime in the next few days. So you don't really have many interested people in that DA's office now. I wouldn't be shocked if they tried it again, but I would be shocked, I guess. I'm saying two things at once.
Yeah.
They shouldn't retry this case, Vinny.
You're saying they shouldn't, but they have the right to if they want to. They could retry him. They'd have a little less evidence, though, right? Because the whole decision was based upon the type of evidence that came in about all this outrageous sexual behavior by Ross Harris. But wasn't all of that evidence of the motive? I mean, aren't prosecutors entitled to make the argument and have a theory as to why someone would do something so outrageous like kill and murder his own child in a heinous way? Don't you have the right to demonstrate a motive for it? Which is what they argued. All of this behavior was such a big part of who he was and what he wanted, and the only way he could obtain that life was without his son. Why can't prosecutors just try the case they want to try?
Well, I guess maybe we shouldn't have rules in court, should we, Vinny? I mean, we just do whatever we want and not really be a fair court. I mean, there's rules for a reason. And you have the Georgia Supreme Court, who's a very conservative court. You have the Justice Namis, who wrote the opinion, who's the former U.S. attorney for the Northern District of Georgia.
There were three who disagreed, so it's not like it was a slam dunk here, Lawrence, right? There were three that disagreed, and yeah, it was prejudicial evidence, but was it unfairly prejudicial, or was it prejudicial in this prosecutor trying to explain to this jury why Ross would do something this outrageous?
Vinny, look, I'm not saying you can't ascribe motive to a criminal action, but what the court is saying here, 6 of the 9 justices are saying what they tried to bring in as evidence was extremely prejudicial. For example, they found penis pictures in his phone, and the state of Georgia blew those pictures up into 9 separate exhibits to show his penis to the jury. And I remember an oral argument, Justice Nami's pushing and questioning, what is the relevance of that? Why do you have to blow up his penis and show it to the jury? Is that just prejudicial? Isn't this just bad character? Or the fact that he slept with 3 prostitutes a couple of years ago? What does that have to do with killing his child? Focus in on the whole thing. What was going on at the time of the incident? What did he do? And connect the dots. They didn't connect. Talking about what happened the day of, leading up, maybe not so prejudicial, but going years back about what he did, that's where prejudice comes in. And, again, I may be going really far afield here, but there's a famous book called The Stranger, and I always talk about it, by Albert Camus, written in 1948. Great French Algerian philosopher. That book was about a trial and about a murder, and all the book was about bad character. It had nothing else to do with the actual case itself. And I use that as a frame of reference because I always think about this case in that way. This is nothing but describing bad character to somebody and not really focusing on what the heart of the issue was. Was there a crime committed? And that's the difference between criminal law and civil law. Criminal law, you have to have the mens rea, which is the mental intent, and the act itself. The actus reus, they call it.
But I mean, showing the extent that he was obsessed with sex, showing the extent, don't you have to bring that all in and not just kind of say, oh, well, he had an affair and that's why he killed his child? No jury's gonna understand that. But for this jury to understand to the extent that it consumed Ross Harris, they had to bring in this evidence and bring in all these women that he was doing all these things with and where he was doing it and when he was doing it. And it ties all into the day, because the day of, he's sexting away.
Well, and I'll read the quote by Justice Nahas if you want me to. I mean, I don't think so. I mean, I think, like he says, I mean, look, they didn't connect the dots. I mean, what did they do? And the fact that he was doing what he was doing, they never were able to put that into, connect the dots, that because he had slept with 3 prostitutes, therefore he killed his child. You and I have talked about this 1,000 hours. If he had killed his wife, then I could see all that stuff being really relevant, because he wanted to get away from his wife and thus he was having affairs, so he killed her. But because he was having affairs and he killed his son, those dots were never connected. I mean, and Justice Nahas said, and this evidence did little, if anything, but it likely led jurors to conclude he was the kind of person who would engage in other morally repulsive conduct and who deserved punishment, even if the jurors were not convinced beyond reasonable doubt, they purposely killed Cooper. And that's the whole point here. They presented all this evidence to show he was a bad guy, but it didn't connect the dots to show intention. And that's what the Supreme Court of Georgia found. And that's what trials are supposed to be. They're supposed to be a place of fairness, where people are tried on equal footing with the with the power the state holds, and can make these grave mistakes and put people in prison with prejudice. And I see flashing here on my screen, you're showing some clips about the veterinarian with the hot car. I mean, think about all the things in this case that Cobb County Police came out and said when this case first started that got this case going, and it all turned out to be not true. Ross Harris never Googled leaving a kid in a car or leaving a dog in a car. None of that was accurate.
Lawrence Zimmerman staying with us. Lawrence, I'm going to bring in some more folks that you know. Stay where you are. We've got a lot to get to. But as we go to break, let's not lose sight of little Cooper.
Say Bob. Say Nana. Say banana. Cooper. Say Bob. Say Nana. Say banana. No, banana. All right, one more time. Cooper. Say Bob. Say Nana. Say banana. Say banana. You want it? Okay.
3870.
There's not a person in this world that doesn't have faults. Some are more serious than others. You have faults. We have faults. Everybody in this world has faults. But people that have faults, that has nothing to do with wanting to murder their child. Just because you have a fault, you cannot connect that fault to wanting to murder your child. I mean, that's insane. But that's what happened with Ross. His character was assassinated before the trial ever started, and that character assassination was linked to the murder charges. And we want a fair trial where the character assassination is not linked to the evidence of the murder. That's what we want, a fair trial. He has an admitted addiction, and he was wanting to get treated for that addiction.
He was getting treated.
He was getting treated for that addiction. And that addiction was what the courts, that's the addiction I was talking about, the sexual addiction. What can I say? They decided that would be the best way for them to succeed, was to tie his sexual addiction into the murder charges, which I think anybody would normally think that's just not fair. That's not fair at all.
Those are the grandparents of Cooper Harris speaking to me a while back about their son who was convicted of the murder of Cooper. That murder conviction overturned by the Georgia Supreme Court. They said some of that evidence related to Ross Harris's bizarre sex life was prejudicial and unfairly prejudicial. Carlos Rodriguez was one of the attorneys for Ross Harris. He spoke earlier today. Take a listen.
The police jump to conclusions, okay? And that should never happen. So police ought to investigate honestly, seeking the truth. And the reality is that what happened on June the 18th, 2014, is exactly what Ross told the detectives happened, that this was an accident. So I believe, yes, when a tragedy like this happens, okay, and a child is forgotten because of a memory failure, and it happens that a child tragically dies, that is not the result of criminal intent. And so, yes, that person should never be charged. I promise you, the punishment that has fallen upon Ross and Leanna and the family, and having to live without Cooper Harris, that is punishment enough.
Was there criminal intent? Because that's what he was convicted of. And if they retry him, that's what they've got to prove. Still with me tonight, the attorney who represents Leanna Taylor, Lawrence Zimmerman. Joining us now, a lot of familiar faces in Atlanta, Georgia, criminal defense attorney Meg Strickler, trial attorney, family law attorney, and law professor Randy Kessler. And joining us from Aruba, criminal defense attorney, entertainment attorney, former assistant district attorney for Atlanta, Daryl Cohen. And because he's the furthest away, I'll begin with Daryl. Daryl, was there criminal intent here? Did Ross Harris commit an intentional crime in leaving little Cooper in that back seat?
Vinny, the answer is yes, in capital letters and italics. Bold it. Look, throw out the sex part. Forget the sex part. Did he stop having pictures taken of his toddler at Chick-fil-A? Yes. Did he drive less than 2 miles from Chick-fil-A to the home of Home Depot? Yes. Was he driving something that was called an SUV? Yes. But was it the tiniest SUV in the history of the universe? Yes. Did he then later in the day go buy light bulbs, not even look in the car, and you can see it from the cameras from when he was in the parking lot, and throw them in? Oh yes, there was intent, nothing but intent, regardless of what the reason was. Whether he wanted to be free to text and sext, that's up to him. But yes, there was intent. And yes, in my view, he was guilty. And yes, in my view, after reading part of the opinion, Justice Namias is wrongest.
Did you say wrong?
Oh my. Daryl's insulting our Supreme Court Chief Justice. Look, Vinny, it's like deja vu all over again, right? We did this, we talked about it, and always when we talk with you, Vinny, we argue that prosecution doesn't need to prove motive. What does it matter what the motive is? Well, you know when they go to motive? When they need it because they don't have enough evidence, direct evidence. And here, they didn't have it. And yes, was it prejudicial? Of course it was prejudicial. All evidence should be prejudicial. Why else use it if it doesn't help prove your point? The question is not, is it prejudicial? The question is, did the prejudicial value outweigh the probative value? And that's where the Supreme Court stepped in here and said, at this point in time, the prejudice was too much. It undid, it made it unfair to the defendant, and they should not have had that kind of imbalance. The evidence was too prejudicial for this case. I disagree with Daryl. I agree with LZ, with Lawrence Zimmerman, a fine lawyer.
Andy, you have a right to be wrong.
No, I disagree with Daryl as well. I mean, they went too far. When you look at the evidence that they did give and what you see in this opinion, it is well written, and it's actually very refreshing to read that he's saying in the majority opinion, look, there was too much. You could have proved some of this salacious stuff, yes, but you don't need 9 witnesses. You don't need hundreds and hundreds and hundreds of text messages. And as LZ said, the erect penis and all those pictures, you don't need 9 blow-ups of that. That was the bridge too far. They could have just toned it back a little bit. Trial judges are granted a lot of discretion on allowing this prejudice versus probative value. And I think when you look at this opinion, it's 155 pages or however long. It's a long, but very detailed, great read, actually, and just shows the prosecutor went too far. The prosecution went too far. And I agree with Daryl, though, on the one point. That was the tiniest of all SUVs, and it is difficult to fathom the throwing in the light bulbs and not getting a smell or a thought of the child. That's the part with Daryl I totally do agree with.
Yeah, Lawrence, let me ask you, Lawrence, you know, at the end of the day, when he gets into the SUV, there's no immediate response. He's driving for, I don't know, 5 or 6 minutes before he pulls over into that strip mall, and then all of a sudden, you know, begins getting out of the car, walking around, everything that we saw in some of the videos. Why does it take 6 minutes? Why does he not smell him? Why does he not realize anything? What is it? Why did it take so long? People have a difficult time with that. How did he forget in that 3-minute drive from Chick-fil-A to Home Depot that his son was in the back seat?
Obviously, those are valid questions and valid points, and they'll, you know, whether they want to be relitigated or not. I mean, but things happen, and humans are flawed, and, you know, I think not Dr. Diamond, I don't think he was able to testify, but the other doctors spoke about memory and reacting to things that I may be wrong. I can't remember if there was testimony that Ross Harris actually had an issue with maybe smell. So, but I don't know. Let's just go back to video. When things extraordinary happen to people, sometimes we don't react as quickly as we think we would. I mean, heck, look at all these mass shootings. I mean, you would think you could just run out of a supermarket as soon as you heard someone shooting, but people are stunned. People don't realize what's going on until it's too late. And so Ross Harris didn't realize till 6 minutes later that his kid was in the back of the car when he looked back or went to get out. I mean,
you can't even say that with a straight face. You can't even get those words out of your mouth with a straight face. You've got to be kidding me. Here's a man that came from Chick-fil-A, drove 5 minutes or less to his office, didn't remember his child was in the car, came out in the middle of the day, oh, come on. This is, you can't even say it with a straight face. I get who's paying you, but no.
Daryl, first of all, I'm not being paid by anybody. Secondly, Daryl, show your face. We can't even see your face on this TV show. Don't talk about me saying something with a straight face. You're hidden behind a picture from 25 years ago. You don't even look like that anymore.
Oh my,
so, listen.
Look, they're both right, Vinny. They're both right. Everyone's right in this case because this is not a kind of case where the prosecution had absolutely no right to raise this kind of evidence. They did have to show why he did this because they didn't have good enough evidence. So it was not anything
it's not because they didn't have good enough evidence. It's because you have to explain to a jury, why on earth would a man do this to his 22-month-old son? It is such an outrageous accusation and act. There has to be an explanation. And don't prosecutors get the opportunity to prove that to the jury? And here, it's not like he's having an affair. This guy was like beyond this was beyond obsessed. He was consumed. This was his whole life. This sexting, these affairs, these prostitutes, these underage children. I mean, it was beyond just like having an affair.
So Vinny, if he kicked his dog 30 years ago, is that admissible too? Just to show the kind of person he is?
No, because that was not what. And Daryl is going to show his face. There's Daryl.
There he is.
We got him. So, and he does still look the same, by the way.
We're both hotel rooms.
But it's relevant.
He still has more hair than me and Randy.
This was all the centerpiece and relevant to the prosecution's theory of the case. Aren't we entitled to present our cases the way we believe the evidence lines up?
But you can't go overboard. That's what I'm saying. And that's why I like this opinion. I like the opinion because it points out that you need to have a balance. And the whole point of why it's overturned is that
that's the life he was living. He's the one who wasn't balanced. Yeah, if Ross Harris had a balanced life, maybe the jury would have heard about it. But they were just hearing what his life was. I mean, was anything untrue that they presented? No.
But Vinny,
he's guilty of being a pervert, right?
That's what Justice Namias said. Vinny, every court in the United States, federal and state, all have rules against bad character evidence. Justice Namias wrote, contrary to the state's theory, a man does not normally enhance his ability to have sexual relationships with women by killing his young child. Also contrary to that, the impediments that marriage places on sexual relationships of multiple partners are normally overcome by cheating, divorce, or in criminal situations, murdering one's spouse, not one's
but
child.
That justice is proving my point, because that justice is comparing this to the normal cheater. The whole point of the prosecution's case is that this guy was overboard. And you're saying the evidence is overboard. It's because he was overboard. And they were just trying to paint an accurate picture of who this guy was. Help me, Daryl.
Vinny, the opinion narrows down.
He was overboard, B-O-R-E-D, and so therefore he did things that he should not have done. And there's no way, when you look at the backseat of that alleged SUV, that he didn't know his child was there. You can't say that with any semblance of truth. You can't, Lawrence. And you may believe that Justice Namias writing the opinion was correct. I think he was dead wrong, by the way, and I don't mind saying that. But the truth is, you have to bring in prejudicial evidence. Meg, maybe they brought in too much, but what is too much? Had the jury found him not guilty, they would not have been brought in enough.
But Daryl,
by bringing in, yeah, Randy.
Daryl, you know, we got to err on the side of caution, right? We protect the innocent. We give the defense the benefit of the doubt in this country. And that's why, if you balance it, and if you're not sure, defendants win. And we would always rather have one or two guilty people go free than anybody that's innocent be in jail. And so you're right, Daryl. Maybe he was guilty.
All right.
But that's why you have 12 men and women on that jury to make that decision. No one else made it but those 12 men and women.
With proper evidence.
Unanimous.
All right. Great job by everyone. What we're going to do here is we're going to dismiss Lawrence Zimmerman, okay? We're going to dismiss Lawrence. But I appreciate your time, Lawrence. I know everyone's calling you. Meg, Randy, and Mr. Aruba, Daryl Cohen, staying with us. When we come back, also, we're going to talk about what's on our docket tonight, the Nipsey Hussle case coming up.
ec.edu.
On the docket tonight, the murder of hip-hop legend Nipsey Hussle. Chanley Painter has more.
Artist in this video earned his first Grammy nod from the album this song originated from. He was also known as Ermias Askedome and had been gaining notoriety for tracks like this on his mixtapes.
Hold me down through these troubled times. Be another victim to my stubborn pride. Stuck in the ground, look me in my eyes, call me on my lies.
In his rise to fame, he began directing some of his energy towards business ventures. This Marathon clothing store, which is now closed, was one of these ventures. It sits right up against Crenshaw Boulevard, the cultural spine for LA's Black community. The larger area where this store lives, South Central, was also Nipsey's home. And on March 31st, 2019, in this parking lot, in the community where Nipsey lived, shots erupted, and Nipsey Hussle was killed.
Mr. Askedome was a father, he was a son, he was a brother, he was a successful artist, an entrepreneur, he was beloved in his neighborhood, he was respected, and he was just 33 years old.
The shooter was Eric Holder. Like Nipsey, he was a local of this community.
They both grew up in South Los Angeles. They both grew up in a neighborhood of hardworking men and women, but also a neighborhood that was claimed by one of the largest criminal street gangs in Los Angeles County. That gang is the Rolling Crips.
Being part of this gang affected the direction of each of their lives and dictated the interactions each of them had with gang members. It was this way of life that set off a chain reaction of events in front of Nipsey's Marathon clothing store.
In the gang world and in the criminal world, there are images from movies, Scarface, where rats or snitches have gotten their just desserts, so to speak. There was a conversation between Mr. Holder and Mr. Askedome minutes before Mr. Holder shot and killed Mr. Askedome. And you will hear from at least two different witnesses that that conversation had something to do with snitching. There's a range of consequences for people who snitch, but no gang member wants to be considered a snitch.
Not long after this conversation, Holder indisputably fired upon Nipsey.
On March 31st, 2019, Eric Ronald Holder Jr. shot and killed Nipsey Hussle. But he was shot literally from the bottom of his feet to the top of his head.
As a result, Holder was charged with 1 count of murder, 4 other felony counts that correspond to the injuries of 2 bystanders, and 1 count of possession of a firearm by a felon. The state says Holder's actions were premeditated and deliberate.
You're going to hear and see evidence that he had plenty of opportunity to think about what he was going to do before he did what he did. And I make that point because we charge not just murder, but premeditated and deliberate murder.
On the other hand, the defense says Holder was provoked.
So the heat of passion in this case relates to snitching, an accusation by Nipsey Hussle that Mr. Eric Holder Jr. was a snitch. That so inflamed and enraged Mr. Holder, the evidence will show that without thinking, a few minutes later, near 9 minutes or so later, Mr. Holder returned and shot Mr. Askedome. He did not have time to cool off.
Now, a jury of 9 women and 3 men will decide which direction the evidence points. potentially leading to a sentence for Holder of life in state prison or the ability to walk free back to his and Nipsey's home of South Central.
And Court TV's coverage of the murder of Nipsey Hussle trial begins tomorrow. When we come back, time to hear from you. Our 13th juror asked you about the hot car death case. Is it possible to forget your child in the car all day long? Your verdict next. Oh.
Just didn't really seem to have a huge awareness of, you know, what time we needed to be there, how long it took to get there, and how long it actually took for him to get ready.
Okay. Would you characterize him as absent-minded?
Somewhat, yeah.
As Leanna Taylor, talking about Ross Harris being absent-minded, and I asked you on social media today, 13th juror question, do you think you can leave your child, your baby, in the car all day long? Does that make sense? Comment of the day today from Rini, who says, no way. However, I agree with the court. It doesn't matter what he was doing all day. What the issue was that he was responsible for that child. Meg Strickler, your thoughts about accidentally leaving your child in the car, you know, not for a moment, not like we run this store, oh, we left all day long.
Listen, I was married to a very absent-minded person, and we had 2 kids together. And there's no way you would forget. As a mother, I think we're genetically like made up. We'll never forget somebody in a car for hours on end. But this, he went back to the car. He even texted about the kid at 3 o'clock, calling him buddy. He did not forget this child. There's no way he did this.
Karen tonight, Vinnie, somehow leaving a child in the car does happen all day long is concerning. Randy, that's you know, another part of this case that people were having a real hard time with.
Well, I don't think the issue is, did he forget all day long? It's not like he forgot, and then he forgot again, and then he kept forgetting. He, in his mind, didn't think the child was in the car, so it wasn't like all day long he was forgetting. He thought he dropped the child off. It wasn't a thought. It wasn't like he continually forgot. It's just the forgetfulness was when he got out of the car and left the child in the car. He forgot that, and then he moved on. Obviously, if he remembered, he would have done something. He wouldn't have walked in front of security cameras, opened the car door, put light bulbs in where he would have been obviously in front of his child. It just doesn't seem like there's enough evidence beyond a reasonable doubt to convict. And I think that's why the Supreme Court said, if you want to try it without all that extra stuff and decide, did he intend this or not? Tough one.
Daryl Cohn, we have about 30 seconds. I'll give you the final word tonight.
He walked back to the car. He never looked in the car. He looked over the car when he threw in light bulbs. And who throws in light bulbs? You drop them gently. They can break. We know that. He is guilty. And by the way, the Hilton Aruba says hello to all of you.
Fantastic. Daryl, have a good time. We appreciate you jumping on tonight during your work trip. Meg Strickler, Randy Kessler, always great to see you as well. We'll see you again really, really soon. Folks, before I go tonight, I have to do this. A foolproof way to never, ever, ever forget your child in the car seat. Next.
Delph@magicspoon.com.
All right, folks, if you are a parent of a young child or grandparent, foolproof way to never forget the child in the back seat. Put the child in the back seat, take off your left shoe. Put the left shoe in the back seat with the child. Trust me, you will not walk out of that car without your child. Okay, before we go tonight, have some business to take care of. We have a missing child out of Minneapolis, Minnesota, Miles Cloak, 13 years old. 13 years old, missing since June 6th of this year. If you see him, call 911, 1-800-THE-LOST, or you can call the Minneapolis Police Department. Take a look at the face, think about him, you see him, pick up the phone. Let's see if we can get him back to safety. Thank you so much for watching. I'm Vinnie Politan. We do appreciate it. Have a great night. And as always, please don't forget to hug the kids.
Proceeded to rape me and then told me to take a shower, kept the shower curtains open, and he sat on the toilet with the machete, just twirling the machete in his hand.
He was trying to rip my head off, and he grabbed onto the back of my head, and he forced me into the ground, stood on top of me, and he just started to chaw away on my head.
If he gets this knife away from me, he's going to kill me.